Let's go to Article 1194. Article 1194. In case of loss, deterioration, or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. So let me discuss to you the following rules that shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition according to Article 1189. The first one is, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. For example, Mr. Bean promised to give his camera to Marvin once he got an A on one of his subjects. Marvin wants this camera so much, so he worked hard and got an A on math subject. Unfortunately, during the typhoon, the camera was drifted by the flood and it got lost. The obligation is extinguished or void. It means that Mr. Bean is not liable to Marvin even if Marvin got an A on math subject. Mr. Bean, as a debtor, has no fault and is not liable for a fortuitous event. The second one of the rule is, if the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. In the same example, if the loss occurred because of the negligence of Mr. Bean, Marvin will be entitled to demand payment to damages. The third one is, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. For example, due to the earthquake, the camera of Mr. Bean dropped on the floor and it deteriorates. Since Mr. Bean has no fault, Marvin will suffer the impairment of the camera. The fourth rule is, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. If the camera is impaired with the fault of Mr. Bean, then Marvin could choose rescission, and he would not be receiving the camera but only the payment. If Marvin would choose fulfillment, then the camera will be delivered to Marvin's face with payment to damage. The fifth one is, if the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. So, supposedly, the market value of the camera increased. Who gets the benefit? According to fifth rules in Article 1189, Marvin will benefit as he is the creditor, since he is the one to suffer. If the camera deteriorates, then it should be also on his favor if the camera improves. Number 6. Rules. If it is improved at the expense of the debtor, he shall no other right than that granted to usufructuary. Mr. Bean bought a tripod for his camera before Marvin got an A grade on his math subject. Mr. Bean would benefit the camera with tripod, but just temporarily, because soon it would be Marvin's camera. But since he paid for the tripod, it's his. He could take it, but not the camera. This rule is about temporary enjoyment of something that you own, but sooner will be owned by someone. Now, let's proceed to Article 1195. Article 1195. Anything paid or delivered before the arrival of the period, the obligor being unaware of the period or believing that the obligation has become due and demandable, may be recovered with the fruits and interest. This article is about payment by mistake. For example, on January 1, 2021, Gian borrowed money from Kwang Il worth 50,000 pesos payable on January 1, 2023. So that is 2 years with 6% annual interest, which is worth 3,000 pesos a year. Jian believed that the due of her loan is on January 2, 2022. She paid 50,000 plus interest worth 6,000 good for 2 years. Obviously, she paid by mistake. The presumption is the debtor, who is Jian, knows her obligation, so in this case, she has to prove that she paid by mistake. So, when will Jian be able to recover her payment? She would be able to recover the principal amount, which is 50,000, before its maturity date. On the other hand, the interest or the fruits would be able to be recovered even after the maturity period. Article 1195 has no application to an obligation to do, because you can't undo the service you've done, and at the same time, it couldn't be applied to an obligation not to do, because you can't undo what you haven't done. So Article 1195 only applies to an obligation to give. Article 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances it should appear that the period has been established in favor of one or of the other. Article 1196 is a provision of benefit of a period in an obligation. Two parties had agreed upon a fixed period, and its presumption is to establish the benefit for both creditor and debtor. The effect of this presumption: creditor can't demand advance payment from debtor, and at the same time debtor can't accept the demand of creditor to fulfill his obligation before the payment due. For example, Jiho issues a promissory note for her rent payment to Sihi, demandable on September 7, 2021. So Jiho can't insist payment before the due date, and at the same time, Sihi can't demand advance payment from Jiho. There are two exceptions for the rule. The first one is term is for the benefit of the debtor alone. He cannot be compelled to pay prematurely, but he can if he desires to do so. It only means debtor can oppose a premature demand for payment, but at the same time he could pay on or before the period expires. The second exception to the rule is if the term is for the benefit of the creditor alone. He may demand fulfillment even before the arrival of the term, but the debtor cannot require him to accept payment before the expiration of the stipulated period. It means creditor can demand performance at any time, but the debtor cannot insist prepayment, because one of the reasons is the interest that the creditor will soon get will possibly decrease. On the other hand, it's possible for creditor to allow prepayment if there is a waiver that allows the debtor to pay before the period. For example, Jiho binds himself to pay Sihi on September 7, 2021. That is for the benefit of both creditor and debtor. The second one, Jiho obliged himself to pay Sihi within 2 years. Then, it is for the benefit of debtor. She can pay advance voluntarily but cannot be compelled to pay advance from the creditor, which is Sehi. Jiho binds himself to pay Sehi on demand. This case is benefit for creditor, which is Sehi.